So I'm Eulalia Hernandez, and I'm an attorney and clients' rights advocate with the Office of Clients' Rights Advocacy. And the Office of Clients' Rights Advocacy is part of Disability Rights California. And in the live audience in front of me, does anybody mind raising their hand if they're familiar with Disability Rights California, if they've heard of disability? Great.
Okay,
Great.
so almost half for people online in the live audience seem familiar with us, which is fantastic.
And so Disability Rights California, for those of you who don't know, we are a legal nonprofit in California, and we provide legal services to people with disabilities. And we have different grants in Disability Rights California to serve different populations or to work on different issues. And our particular grant, the Office of Clients' Rights Advocacy, is a grant through the Department of Developmental Services to serve regional center clients specifically. And each regional center has a client's rights advocate and an assistant client's rights advocate. So we're the client's rights advocate and assistant client's rights advocate for North Bay Regional Center. Yeah.
So we serve Napa, Solano, and Sonoma counties. But like Eulalia was saying, there's an office like ours at every regional center. So all throughout California, we're here to protect the rights of people who are regional center clients and have developmental disabilities. And so I'm Annie Brewer. I'm the assistant client's rights advocate, and I'm just really happy with the turnout and happy to be here. And it's wonderful to see such interest for this topic, because it's a very important one, and we're happy to be here to talk about it with everyone, and can't wait for your questions after. I think that'll be a really important part of this presentation, to have a nice discussion. So please use those question cards and hang on to them, and we'll be sure to try and answer questions the best we can afterwards. So we have an agenda, and these are just the items we're going to be going over today. We'll start with an introduction. We'll go a little bit more in depth about our office. We're going to talk about transition to adulthood, communication, capacity and consent, advanced healthcare directives and powers of attorney, and then other decision-making options, and then we'll talk about conservatorships. It's really important that everyone here understand what they are, so we really want to go through them because as you'll get to know throughout our presentation and our stories about clients we've assisted, conservatorship, the word and the actual conservatorship, it's thrown around a lot, as far as how to help people with developmental disabilities, but really going in depth about what a conservatorship is and what it means is what we hope to accomplish today. So an introduction to our office. So as Eulalia was saying, we provide legal advocacy services for clients of the regional center. And so what that means is we provide assistance in a lot of different areas, and we'll talk a bit about that. We help with areas like public benefits, so Social Security, Medi-Cal, with denials of certain services through Medi-Cal or SSI overpayments. Those are kind of some of the benefits issues we get involved in. We help with California Children's Services issues. So if anyone's having trouble with their benefits and their regional center client, they can contact our office and we could provide advice or get more involved if needed. We also help with IPP meetings, the individual program plan meeting with the regional center. We can help consumers of North Bay Regional Center. For us, we can help with their meetings and help people get services that they need from the regional center. And we also help with special education advocacy. Sometimes that's just counsel and advice about how to prepare for an IEP meeting or to request an assessment through the school district, or sometimes we're able to provide representation at IEP meetings.
And just one of the other, switch sides so folks online can see us. One of the other pieces I think that maybe a lot of folks in the audience and online are familiar with Disability Rights California is our publications, and that's a big piece of what we do. Our broader agency is develop publications regarding different rights, like the Special Education Rights and Responsibilities Manual that I'm sure a lot of you are familiar with, as well as the rights under the Lanterman Act and publications regarding in-home supportive services. So just be aware that if you haven't looked at our publications site on our website, which is www.disabilityrights with an S, ca.org, disabilityrightsca.org. The publications, we just have a really wide just breadth of information on our website. So I didn't want to forget to say that.
Yeah.
And yeah, so as Annie was explaining, the Office of Clients' Rights Advocacy, the different types of advocacy that we do, it's a really broad range. We do individual advocacy, we do outreach and trainings and meeting with the public and consumers. We do a lot of clients' rights trainings at day programs, at group homes, at self-advocacy meetings. So we try to get out there so people know who we are, so they can contact us if there are issues, and also so that we can kind of hear what's going on, because sometimes, you know, the calls that we get, we might not hear of some of the systemic issues that might be coming up. So it's nice to meet with people and hear what's happening in the community as well.
And it's one of our objectives in our office and goals is to reach underserved populations. So we do a lot of outreach to groups that we've targeted in our community who may not be receiving as many services as others. So it's very important that we go out and outreach to different communities to make sure people who that everyone's getting the information about services and supports. And so that's a big goal of our office.
And so just in switching to the Lanterman Act, so the Lanterman Act is the set of laws in the Welfare and Institutions Codes that creates the regional centers and creates people's right to access services and to that enable folks to live independently or as independently as possible in the community. So that's a good starting point when needing services or help.
Yeah.
And then we have kind of medical advocacy, because a lot of the issues that we hear regarding conservatorship come up regarding someone's in the medical field. And so, you know, we'll get all kinds of questions regarding someone's ability to consent or not to consent to medical treatment. And so we just have some examples of the advocacy that we can provide. One area that we helped with was we got a call from a family member that said, you know, my son has a girlfriend and he wants a vasectomy. And so we said, okay, and you know, she wanted to know what the rights were in order for him to get a vasectomy. And because we're the client's rights advocate, we're directed by the client. We said that's great. We have to go out and meet with him before we can kind of provide any advice as to what the next steps were. And so I researched as much as I could about vasectomies, and I went out and met with the young gentleman, and I explained to him what a vasectomy was, and it turned out he didn't want one. And so, you know, so that kind of directed our advocacy. He gave me permission to share that information with his mom, and you know, that was kind of that. And she actually thanked me for meeting with him. So we're kind of, we try the best we can, but we really, it's important to meet with the individual, because most of our calls do come from family members first, and we want to try to figure out what the individual would want and then provide advice. And then on the other side, you know, I had a client who, she already had some children, and she didn't want any more children, and she wanted to have a tubal ligation, and the hospital was absolutely against it. Her doctor wasn't, but the surgeon and the hospital in general were concerned because she had a developmental disability. They initially said yes until they found out she had a developmental disability. So we were on the other side of trying to, get the regional center support and do like a psychological assessment and counseling that she understood what this meant. So it's just interesting how our role shifts depending on what a person might want.
And I think, we're going to probably keep going back to communication, and we're going to do like a big, chunk of this presentation talking about the role of communication and the importance of it. But, that's kind of where we always start with our advocacy, is trying to determine what the individual wants. And so many times we hear that person can't make a decision like that. That person doesn't communicate. They don't know, what they want. But, another situation or case that we got involved in was where a regional center consumer unfortunately had a diagnosis of brain cancer and had a tumor that was causing her a lot of pain. And we got involved when we were contacted when she was being denied treatment, radiation treatment for the tumor, because the doctors felt like they couldn't, she didn't have capacity to make a decision about the treatment, and they didn't understand if she wanted it. There were some side effects, that could have caused some pain. So, first step, like Julia was saying, we went out and met with the client at the nursing facility she was in and broke everything down to her. And yeah, communication was difficult for her, and, big medical terms were hard, as they are for me, to understand. But when we talked it through with her and she really said, my head hurts now, and we explained that there's a treatment that could possibly make it feel better. It might hurt for a bit more, and she said she wanted to have the radiation treatment, and we were able to advocate for that. So, these cases are always complex. They're always different. We just really want to emphasize today, it's about trying to determine what the person wants and going from there. Instead of kind of a blanket, they can't make that choice. Let's start by trying to see if they're able to. So we're going to start out by talking a bit about transition to adulthood. It seems like this is the time when, conservatorship starts coming up. Parents and family members are told by school districts, you have to get a conservatorship when your child with a disability is about to turn 18. And so we get lots of calls from frightened family members about what is going to happen. My child is turning 18, and I've been told that they're going to be in charge of making decisions about their educational services, medical decisions, and that stuff's challenging for them. So they're going to need some help, and I've been told that conservatorship's the way to help them. And so that's where we, often are able to provide information about alternatives to conservatorship to family members. This happened, as I said, it happens very frequently. Just last week, I got a call from a mom who said the school district said she had to get a conservatorship. Luckily, she had been calling around to conservatorship attorneys and was like, this is way too expensive. I can't afford this. So it gave me a moment to really be able to talk with her about alternatives. And so we went through all the areas she was concerned about: medical, school, regional center, about making sure her child who was going to be becoming an adult would get the support they need and services they need. And at the end of our conversation, she was really pleased and said, I didn't realize there were all these other options, and I don't think a conservatorship is necessary. And so that was fantastic. We love when that happens. But we just really want to talk about how transition to adulthood is kind of the time that this conversation starts. So we feel like, it's just a really important time to start discussing the individual's support needs and their ability to make decisions and what that looks like. So preparing for when the individual is going to be turning 18, to see and kind of start thinking about the supports that they're going to need to be able to make choices about, medical procedures and educational services. And like I was saying, so often parents are told by different providers, you have to get a conservatorship. And, I think that these providers, they mean well, but it's an educational issue, not, you know, we've all been told, like, the only way for you to help a person with a developmental disability make decisions is by getting a conservatorship. But in fact, we're here to tell you there are lots of alternatives. So we're gonna go through a lot of the medical alternatives, but also throw in a lot of examples of different types of alternatives. And some of those include the Advanced Healthcare Directive, which is a power of attorney. And so we've helped individuals in our office who have been in need of like dental care and been told who are over the age of 18 and been told they can't make their own decision about their dental care, like getting a surgery, a dental surgery. We've helped them, you know, sometimes establish a power of attorney, which is where you can have another individual in your life appointed to help you make medical choices, and Joelle is going to go into a lot of detail about what that is. But you know, we've had frantic families call our office, say, my child just turned 18, he had surgery set up to go to UCSF, and then we're being told they can't do the procedure because he has a developmental disability. And there's an alternative other than getting a conservatorship at that point. You can do a medical power of attorney, and then the individual was able to get their procedure done. It's a less restrictive means of helping someone make medical decisions and get the support they need to make medical decisions. As far as special ed goes, you know, as much as school teachers and educational providers are saying that you need a conservatorship, there's a very simple form that can be used called an assignment of educational decision-making. Assignment of educational rights and decision-making. And it's a form that can be printed out online, and the individual with the disability who's over the age of 18 can sign it and appoint their family, whomever, to help them make educational decisions. And that can be used, you know, in place of a conservatorship. Very, you know, a lot less restrictive. It can be, you know, all these alternatives that we're going to be talking about are so much less restrictive because they can be easily revoked. They can be easily changed. As we know, things change in our lives. You know, if I appointed my mom to make decisions in my life, that might change, you know, 10 years down the line. What if my mom's not able to help me at that point? I might want to appoint my father. I might, you know, and so when you use these less restrictive means like a power of attorney or the assignment of educational decision-making, those can be revoked or changed easily, which is fantastic. A conservatorship it's a lot harder to change. You have to go through a court process. And then just release forms are a way that, you know, people can be involved in a person's decision-making as far as like regional center services. You can sign a release form, and then the individual can sign a release form allowing the regional center to communicate with another person about their services. So that's another less restrictive way of helping an individual make choices about the services they receive. And then for Social Security, because that's another area, finance is another area that parents and family members are told you need a conservatorship. But you know, there's a financial power of attorney that can be put into place that would be sufficient to help an individual make financial decisions and be involved in their finances to support them in making those decisions. And then if the individual's on Social Security, there's the representative payee. You can assign, an individual can be assigned from Social Security to make decisions about the Social Security benefits. And so, you know, we've had people contact our office, you know, saying, like very recently, we have a case we're getting involved in now where a client is conserved, and he says, I don't get any of my Social Security benefits. And his conservator has the power to make the financial decisions in his life. So in order to get him access to his Social Security benefits when he's conserved, that's a pretty tough situation. We're gonna have to go through some pretty in-depth steps to try and get him more access to his money. If he just had a representative payee, if I was his representative payee, say, and I was mismanaging his funds and he wanted to change that, he could go to Social Security and, you know, get a new rep payee appointed. So, these less restrictive means are out there, and they just can be beneficial all around. So as we started out by saying, communication is the first step always. Like Jalalia said, when she went out and met with her client who had a totally different idea of what he wanted to do with his body than his mom did, we meet with the individual first and try and determine what they want. Communication is so important and should absolutely be the first step in trying to determine what the individual needs and wants. Just this last week, our office had been called about a client, and we were told that she was nonverbal. The individual who called our office said, "We have no way of determining what this individual wants at all." And so, like we said we do, we set up an appointment to go meet with the client. We went out and met with her. And Jalalia and I left and we're like, nonverbal? She was signing, she was indicating what she wanted through shaking her head. She was so clear. When we asked her if she wanted to start a special education program again, she shook her head, yes, 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 I do. She got so excited. And so, yeah, communication might not be a verbal kind of way of communicating, but there are so many other ways that people speak and let people know what they want. And so it's just taking the time to try and determine what the person wants. And it can be challenging, especially if people aren't familiar with working with individuals with developmental disabilities. Some medical providers aren't, so that can be challenging. But it's really just taking that time to try and figure out what the person wants and needs. We had another client that we helped move. We love this story. And he was nonverbal. And so we, weren't really sure if he wanted to move. We had been contacted, told that, there's this opportunity for him to find a new residential facility. And we're just not sure if he wants it. We kind of want you guys to get involved to see if you're able to figure it out. Well, we met with him. We talked to him multiple times about it, met with him multiple times. And he wasn't very clear, and we didn't know him that well. We couldn't really determine that choice, but we were able to advocate for him to do a visit to the house. So he went and visited the house, and what did he do? He walked right in, walked into the room, laid down on the bed, and just relaxed. He looked so happy, and so his service providers were able to determine that he seemed to like this. I think he visited a few more times, continued to exhibit really great body language and happiness, and he moved, and he's very happy where he's at now. So people communicate in very different ways, and I'm sure as families and parents online and in the live audience, you really know that, and providers as well. So, as far as medical health and medical procedures go, there are legal obligations that physicians and medical providers have to communicate with their patients. And so, a lot of times we don't consider, we might think, okay, a doctor has to, have an interpreter there for ASL, to help an individual with a disability. But what about the people we work with, the people with developmental disabilities that maybe have a really, unique way of communicating? They're still protected under this. The health providers have to make they have to ensure effective communication with their patients. And so it's all about taking that time, and sometimes we have to educate our health providers about how the person we're supporting, or our child, or our family member communicates. But they do have an obligation to try and communicate and engage in communication with the patient. So we like to outline some of those techniques for effective communication. They're really important. And if these steps aren't taken, medical visits and surgeries can kind of go awry. I didn't explain in my introduction, but way back when I was a direct support provider and I was providing support for the individual I served he's a regional center client and has a developmental disability, unfortunately he had to go to the ER. So I took him to the ER, and I'm trying to support him through the visit, and the doctors are only talking to me. He has a pretty severe speech impediment. And so instead of talking directly to their patient, they were only talking to me as the staff person. They were moving him without asking him if it was okay. They were, transferring him onto beds. So it just really opened my eyes to like, oh gosh, if I wasn't here to say something, which I shouldn't have had to. He can speak up for himself. They just weren't listening. But to say, okay, you need to speak with him. You need to direct your communication. He'll let you know if it's okay to move him, if it's okay to do that procedure. So these steps are outlined to kind of highlight how to start that process. So establishing rapport, speaking directly to the person, asking how they communicate. We do that a lot in meetings. If we're kind of having trouble understanding what someone's saying, we'll say, how do you indicate yes or no? Or is it okay if we ask your staff person how you communicate? So those questions are okay to ask. And just really speaking directly to the individual, how important is that if it's your patient? Choosing appropriate language. Sometimes you have to use plain language, so breaking things down in ways that are more easy to understand. Asking yes or no questions, kind of just breaking things down in different ways, multiple times.
And I was just gonna interject, I'm sorry, just quickly, I think this part of the presentation is really good if you're, at a doctor's appointment with your family member, and just being really clear as to what the doctor should be doing or the medical staff should be doing, and not only communicating with you, but trying to communicate with your family member or the person that you're providing services for. So that's kind of this piece as well.
Yeah, I think that's a really good point. Listening and letting the individual letting the individual know if you understand what they're saying or not. I often say, I didn't catch that. I'm not quite understanding what you're saying. Is this what you mean? And just taking that time. It takes a lot of time sometimes to establish communication. Like I said, Jalali and I many times have to meet with our clients multiple times to figure out what they want. That's okay. And then just rephrasing, repeating, checking in for understanding. Is this making sense to you? Asking things in different ways to make sure they understood what you're saying. And so, like I've been saying, communication is always the first step in trying to determine the individual's ability to consent to treatment or to services.
And so the next piece is about capacity and competency, and it kind of goes back to what Annie was describing was, the assumption that folks with developmental disabilities just automatically don't have the capacity or aren't competent to make decisions or to be considered sometimes in decision making about their lives. And so, when we get calls, the first step is that an individual is presumed to be competent to make medical decisions as well as other decisions. So that's the starting point. It shouldn't be that's always what I think about, where we should start off with that assumption instead of that they're not capable of making the decision. And I think a lot of times also when I'm, because we get calls and I try not to get caught up, but sometimes I do. We get calls of this is happening and we really need to take away this right for this individual. And sometimes I might feel like that's in the best interest, but that's not my job. My job is to really stop and say, well, how, find out what the individual wants. But and part of that is I stop and I think, I'm like, do I want someone to take that right away from me? There has to be just kind of a whole analysis of what other ways things can be accomplished before just automatically going to taking away rights. And kind of going back to the advanced healthcare directives, the presumption is that the person has the capacity to make medical decisions, or, you know, and designate someone to help them with that. And that's a really big piece, is that someone might not understand every piece of a surgery or every single piece of a medical decision, but they can say, you know, my mom can help me with this. You know, my mom's been helping me with this in the past, and she can continue helping me with this. And that's what the power of attorney, the Advanced Healthcare Directive, because the Advanced Healthcare Directive can be immediate. There's boxes that you can check that are for it to start immediately, or it can be, you know, years down the line, or if an event occurs. So basically, the Advanced Healthcare Directives allow an individual to name someone else to make healthcare decisions for them, and or with them, you know, and that's kind of how I look at it. And it's generally a form. Some hospitals have their own forms. I think like Kaiser has their own form, but there's also forms online. And basically, the form kind of outlines where they could make decisions in what areas, whether it's all areas or just certain areas, and the individual signs it, and there's 2 witnesses. And this came up, I think Annie gave a little bit of the example that this has come up with more frequently with dental treatment. I think it's a systemic issue that we're gonna have to address at some point, but just basically the automatic, you know, oh, this person turned 18, well, they can't get any help from us, this particular clinic, they can't get any services from us unless they're conserved. And it's just, you know, and I'm talking to the family and the individual, and, well, did they meet you? Have they looked at your records? You know, has there been some type of evaluation that's showing that you can't make the decision? And in this particular clinic, there hasn't been. And it's just basically, oh, their regional center client, they need a conservatorship. And like, luckily enough, this has been effective, that the person hasn't had to be conserved in order to get dental treatment, which we all know can be really necessary and painful if you don't get it. And the good thing with the power of attorney is that if the person changes their mind, or if the person that was their designee is no longer in their life for whatever reason, they can designate another person easily. If that individual were conserved, they would need to go to court to get the conservatorship changed. If they no longer wanted that person to be helping them, or if that person even passed away, they might have another conservator appointed, and it could be a family member, or it could be someone from the county. Those, you know, those are the worst case that we've seen. And so that's why, you know, some of these less restrictive means are good if you know about the consequences in the future, because a conservatorship may seem fine when mom is here helping make decisions, but if mom's no longer here and it's an aunt who lives out of state, and that's who is the next of kin who gets appointed, she might have a whole nother view of what decisions are good for this individual, and she might not have seen the individual in years. And that's something that's come up a lot, unfortunately, for our clients. Like, we had one client, he's lived in the same home, he has autism, and he's lived in the same home for 25 years, a group home. He loves music. They've even created a music room for him. And he loves to spend his money on guitar lessons and save for guitars. And his mom passed away, and she designated another person to be the co-conservator, who has good intentions, but thinks things like, he's never gonna get good at guitar, why does he need guitar lessons? That's a waste of money. Why is he saving for a guitar? He's not, you know, it's a waste of money. I think he should move, because the home is struggling with how to keep her happy and keep him in their home. And it's, you know, he's an individual I've worked with for, you know, since I started here, and I periodically we get these calls, and it's really painful that he has to go through this and have this fear that he can get pulled out of the home he's lived in for 25 years because there was a wrong conservatorship decision made about who could make that decision. And I don't want to, our office, you know, we get the calls when things are going wrong,
we do.
Obviously. And so, you know, we're providing this information about alternatives because we want people to know that there are alternatives to conservatorship, so that you have just all the information when you're making this decision for your family. There are plenty of other agencies and attorneys who will tell you all about conservatorship and why it's necessary. And so our role really is to tell you why they're not, and I think most of the time, why they're not necessary. But again, you know, families have different experiences, but that's the perspective we're here to bring you. It's not always a popular one, but that's what we're here for. Yeah. And so, you know, again, just kind of the Advanced Healthcare Directive. So an individual can choose, you know, how much they want to limit the authority of the person who's going to be making the decisions, or choose just to let them have, you know, broad authority. And it could be with certain hospitals, you know, maybe I want you to talk about or be involved with my medical decisions at, you know, with my general doctor, but maybe not with, you know, like my gynecologist. Maybe I'll do that privately. So you can kind of designate the areas that you want the other person to be involved in your medical decision making. And again, it's more about, you know, the person can maintain the right to have more influence about, you know, medications. Maybe I don't want to have this person making all the decisions about my medication, or I want a check-in before a medication is changed so I can try to understand it more. Or maybe it's fine. Mom's always done my medications and Dad's always done them, and I'll sign off. It's fine. So, and then it kind of goes to some of the end of life parts are in the power of attorney, such as, you know, do I want to make the decision whether I want, and some of this I think is interesting because, you know, there's some, I've seen some power of attorneys where it's like G-tube, do I want someone to consent for that for me? And, you know, for a lot of our clients, that's just an everyday way that you live. And for, you know, in the medical field, that can be a life-ending decision. So it's interesting how, just how much is involved and how many different aspects there are to making medical decisions for someone and really knowing somebody. And then it just kind of goes on about, you know, if the individual authorizes person to dispose of their remains or donate them. So those are some of the things that are really detailed in the Advanced Healthcare Directive. So if there was an Advanced Healthcare Directive, let's say an individual really didn't have any family, and there's a provision in the Lanterman Act, most of the audience knows what the Lanterman Act is, that the regional center director can authorize medical, surgical, or dental care kind of in an emergency situation. I don't think the intent is for the director to make all the medical decisions, but if they're in the absence of anyone else, the regional center can be involved in helping make medical decisions.
And just to add on that, you know, the way that we see this work, at least at the regional center we work at or work with, is that the regional center has a medical doctor on their team, and they have that doctor assess the individual. So it's not like the director, you know, just making a decision. There's a lot that goes into this being authorized. So it's that medical physician meeting with the client, and they often involve our office to go and kind of do that initial kind of check-in about what the client wants. So that seemed to, you know, in the cases that we're involved in, it works pretty well. It's nice to have like a big team involved in trying to determine what the individual wants and needs before it's just authorized. So.
And then there's another provision in the probate code. So there's different areas of the law that are looking at alternatives to conservatorship, is having a surrogate decision maker. And it's a time limited, it's not forever, and you can have a surrogate decision maker. You know, it generally happens from what I was reading, like in the hospital, you know, I want this person. You don't have time to do the advanced power of attorney, and you just have someone else there just helping make decisions. And it could be, you know, during this particular hospital stay or to address this particular condition that you might be dealing with. So those are some of the other alternatives as well. So the conservatorship is an individual or an agency. So an individual, a family member, or agency. It could be the public guardian. The regional center in the past, and some regional centers still do, may petition to be a conservator, and the court appoints them to make decisions for a person. And it lasts until it's terminated by the court. So that's the piece that I was explaining, that if a family member passes away, that doesn't terminate if the conservator passes away, that doesn't terminate the conservatorship. You have to go into court to terminate the conservatorship, and it's not easy. It's really not easy to terminate one once they're in place. I mean, we have a case now where a client was assaulted by her conservator in front of professionals, and has been very clear about not wanting her conservator in her life, not wanting to be conserved, and and the court is reluctant to step in because she needs so much help, and
her communication is different, and I think that makes a big, you know, unfortunately in this specific case is a big holdup. You know, everyone's on board. All of her service providers think she'd be better off without this conservator, obviously. And, you know, unfortunately, the way she communicates is different than some of our other clients or myself if I were to say, I no longer want to be conserved. But she's very clear about not wanting to be conserved. So it's very challenging, even when everyone's on board, to get a conservatorship terminated.
And that's the next piece. So an individual has a right to contest the conservatorship, and they would be appointed a public defender, and a court investigator gets involved. But, you know, sometimes it's as good as the public defender, you know, whether or not they are educated as to alternatives, so it's just really difficult to change once it's established. That's why it's good to think about the alternatives before. And, you know, there's also risks involved. We understand of a client whose parents wanted to conserve her, but they were kind of contentious, living, you know, divorced parents, and both fighting over who would conserve her, and the court got fed up and said, you know what, neither one of you are going to conserve her. We're going to let the county make decisions for her. And the public guardian, and, you know, it's as good as that individual public guardian and their resources to make decisions, and that's, you know, those are some of the risks that can happen. And so one of the, you know, looking at if a conservatorship is appropriate, you know, is the person able to make their own choices? And it's not just, you know, that's such a kind of simple statement, but it's also thinking about having support in making those choices, and learning about what choice they're making and what options they have. So does the individual want to be conserved? You know, we had a client who did want to be conserved. You know, he was like, I want my mom and dad to keep making my decisions, and, you know, that was his right as well. And, you know, does the person have access to support and services to help them understand the choices? and is the person able to provide for his or her needs? So this is one that the court really gets stuck on, judges get stuck on, and they say, well, this person they can't work, you know, they can't live on their own, they can't provide for their own needs, but there's so many, if someone, you know, the courts are educated, they'll understand that there are service providers, you know, just because someone isn't conserved doesn't mean that their family can't still be in their life at helping them. There are assistants to work, assistants to live independently. So there's a lot of pieces to this that don't, that sometimes get overlooked.
Yeah, and just, you know, going back to when we were doing our introduction to this presentation and talking about the Lanterman Act, which so many people here in the room are familiar with. I mean, one of the main tenets of the Lanterman Act is that individuals in California with developmental disabilities have the right to live, work, and be independent in the community, and the regional center is there to provide supports to make that happen, and they do. And so that's, you know, this part, is the person able to provide for his or her needs? It's looking at those services and supports through the regional center and other generic resources that allow that to happen. Supported living services, group home placements, you know, day programs, work programs, like Jalalia was saying. Those are what we need to consider and educate the court on, that, you know, these people with developmental disabilities have access to resources. You know, we're very lucky, actually, in the state of California that these services are available to people with developmental disabilities. So it's tapping into the regional center and getting the support that's needed, and you know, for individuals to be able to be independent and make their own choices and lead independent lives with support.
And so I'm just going to briefly go over, I'm going to be more in depth about, I guess I shouldn't point to the screen since nobody can see it. I'm going to be more in depth about the first one, limited conservatorship, in the next slide. So there's types of conservatorship. Limited conservatorships are for specifically for people who receive regional center services. There's a probate code conservatorship, which is kind of more broad, where you can conserve an individual or their estate. I've seen that. I've seen this. This is the type of conservator that there was before limited conservatorships. The more broad probate code conservatorship, and there's not as much oversight. And of the estate, I've mostly seen that if a consumer's had some type of a like personal injury claim or payout, and sometimes they'll appoint a conservator of the estate to help manage that money. And then the LPS, the Lanterman Shore Act, I've seen that more with clients who are dually diagnosed. It's extremely restrictive, and you know, and I've seen that. Yeah, so that's the LPS conservatorship. Not a lot of regional center consumers are conserved under this, but some if they have also a mental health diagnosis. And then the dementia conservatorship, which I haven't seen for any of our clients, but it's for folks who have dementia. It's specific. So in a limited conservatorship, there's 7 powers. And this is one of the things that when we did this presentation in the past, people were surprised. We just wanted to, you know, we just want to have this person be conserved for medical. We want someone to help them make medical decisions. And all of a sudden, this person who might have needed some assistance making medical decisions about, you know, their medical treatment, all of a sudden they can't decide where they want to live. They can be moved at any time, or they can't decide who their friends are going to be, or who they're going to have relationships with, or even if they can marry. And so all of these powers are there, and the court is supposed to look at each power to see whether, you know, if that power is appropriate to strip away that right. And unfortunately, I think the courts just, for the most part, strip away all of the rights. And that's the scariest part of this, is that, you know, let's say a person just really does need help making medical decisions and there's no other alternative. they might end up stuck in a group home that they don't want to be in, or a facility that they don't want to be in because they're because that power has been taken from them. And I'll give an example, kind of the right to determine residence. We had 2 clients call us from a group home that there had been substantiated complaints of clients' rights issues. And one client was conserved and one client wasn't. The client who we were able to help move was the client who wasn't conserved. The conserved client, the conservator, lived out of state, only was familiar with the group home owner. He was a very smooth talker, and convinced her that those rights violations were no big thing. They were us causing trouble. We do cause trouble, but licensing actually backed us up for once.
It was substantiated.
Yeah, like, you know, and she's still there, you know, and they break my heart,
Mm-hmm.
you know. It's just heartbreaking that this person can't move and can't live, and you know, and she's acting out and probably going to end up in a more restrictive placement, be forced to be somewhere more restrictive because she's trying to communicate. She doesn't want to live there. She's been very clear on it, and her conservator isn't able to hear it. And so those are the hardest ones, that when this gets stripped away, the right to determine residence. Then there's also the right to access, you know, confidential information. Mm-hmm. And the other side of this is if you can always have a release if you wanted to access your family members' records. If you thought that would be helpful and they were in agreement, they could sign a release and you could get access to the records. So it doesn't have to be something that's stripped away from them. And the same thing, you know, going back to the right to determine residence, there's an IPP meeting that can be held with the regional center to talk about, you know, and so that the individual can get the support about making a decision and moving to a different place. So it's not just calling our office and, you know, us making it happen in a heartbeat. There's a team involved. We do it through the IPP meeting, and we get input from other folks as to, you know, where they want to live, or what can change in their current residence so that they'll want to remain there, or maybe it's time to move. You know, so all these powers. There's flip sides on less restrictive ways generally than stripping that right from that individual. And the right to marry. I mean, that's, you know, not everybody, but a lot of people would like to get married and would like to choose who they're going to marry. And that can be taken away from an individual.
And like Jalali was saying, we did this presentation for medical providers, right? So that's why a lot of the focus is on medical services and health and making decisions about healthcare. But when we put up this slide, and these providers, these healthcare providers, saw all these rights that could be stripped from an individual who maybe just needs some help to make medical decisions, they were shocked. Like when Jalali went over the right to marry portion of this, I saw jaws drop. I mean, who would want to have that right taken away? It's such a personal decision. And so there's a lot of really, you know, important rights that can be taken away when someone may need help with one area in their life or two.
And, you know, so it's the right to control a contract. And some of these, so the other side of this is that there are times that the financial power of attorney can help with the right to control contract if it's for if it's getting into like a financial obligation. So that's another alternative. The right to consent to medical treatment. We've already gone over, you know, power of attorney, advanced healthcare directive, and just trying to think. And again, like there's other, you know, we've discussed all the other kind of alternatives and different people that can be involved in helping someone make a medical decision, and just getting support in that. And the right to control social and sexual contacts, that's a big piece. I mean, if you it's your right to have a relationship, to have friends. I mean, there's times where someone wants to hang out with their friend, but if they're conserved and their conservator doesn't like that particular person, or they're fighting with that particular person, and they can deny access for that person to be able to have contact with them. And that's a big piece. We've seen that with, with parents. One parent is a conservator, and they don't want the consumer to see their other parent. And then the right to make educational decisions. And so that's also the other piece that, like Annie went over earlier, that it's the special education assignment of rights that someone can fill out if they still want their family members involved in the IEP process and helping them advocate at an IEP. And so, so the regional center, when someone applies for a limited conservatorship, the regional center should, and so I skipped over to other information about limited conservatorship, so we're shifting just to give more broad. Is that right?
Yes.
Okay.
Yep.
So the role of the regional center is to write a report to the court addressing the 7 powers and discussing which powers they think the person should be conserved under. Now, each regional center does it differently. Some regional centers actually have the case manager who might know the person be involved in writing this report. Other regional centers have their legal specialist or someone who doesn't know the consumer writing the report. They may just be reviewing an IPP and they're writing this report. So it really is, it's a role that I wish the regional center took a little bit more serious. And again, it might be someone might just agree to all the powers or some of them, and they might not even know the consumer well. And since it's a limited conservatorship, not all 7 powers need to be granted. So if you did decide to go that route, maybe you don't want all the powers. You only want a few, and that's what you petition for. And we always, when someone says that they've conserved the client, we always ask for the letters of conservatorship, because some people might be making decisions, wanting to make decisions about who the client hangs out with or who the client lives with or where they live, and in actuality they may only have the power to make medical decisions or educational decisions. So it's if you're a provider, it's good to see the letters of conservatorship. And sometimes people just have a power of attorney. It's not a conservatorship. Mm-hmm. And one of the big pieces is that under a limited conservatorship, it doesn't, for medical treatments, it doesn't apply for sterilization. So if someone wants to be or doesn't want to be sterilized, the conservator can't consent for them under a limited conservatorship. It also doesn't apply to certain therapies, such as electroshock treatments. So just because you have a conservator, the conservator thankfully can't make the decision whether or not someone gets electroshock therapy treatment. Mm-hmm. And the conservatorship is supposed to be reviewed every 2 years. And they're reviewed, but I just haven't seen that many be terminated, even at times that it was really clear that they should be. So they're reviewed, and at that point there could be a time where things could change, but I just haven't seen it happen. Yeah. And just as if we haven't said it, the conservatorship is the most restrictive means to help a person make decisions in their life, and there's just other alternatives to consider before making those decisions.
So the first one says, Advanced Healthcare Directive form. Is it enough to make all medical decisions, including ABA, so behavioral services? Yes. Mm-hmm.
Yeah, because ABA is under the medical now. All right.
Yeah, we believe so. You know, I would check with your healthcare provider. Like we said, Kaiser has their own advanced healthcare directive form. And so you could contact Kaiser if that's your provider and ask them. And go ahead.
And I think one of the alternatives, because that's a good question, and would be also, you know, that the person can sign a consent form, a HIPAA consent form, so that you can be involved in any decision making and discussion about behavioral services as well.
Yeah, that is a good question. Okay, and the next question, is power of attorney different from advanced healthcare directive forms?
So they're the same thing. They're kind of used intertwined. The advanced healthcare directive is probably, I say power of attorney, but it's more the advanced healthcare directive is used more often now, and that's because because you can, it doesn't have to be immediate. You could either, you know, check the box that you want it to start immediately, or you can check the box that you want it to happen in 5 years, or if your capacity has diminished to a certain extent. So they're used in either or, but I think they're more using advanced healthcare directive now. Power of attorney is just less of a mouthful.
The next question, can you carry around something that says you have a medical power of attorney?
So the way that I've seen it is that any medical providers, you submit a copy of the power of attorney, the advanced healthcare directive, to that medical provider. So if the person is seen, you know, I know some folks who have a lot of medical needs might be seen at 5 or 6 different clinics, you know, hospitals for different areas. You would submit the advanced healthcare directive to each one. Hopefully it would be in their file and it would be online, but I would also carry it if you think that it's an issue. You know, bring a copy with you, especially if it's a new provider.
And then this question says, do the advocates have a statewide organization comparable to ARCA, which is the Association of Regional Centers? And we do. It's Disability Rights California. That's our statewide agency. And all of our offices for all the different regional centers are under Disability Rights California. And I see a hand up in the audience, maybe. The audience member said, does Disability Rights California connect and meet to discuss the issues that we addressed today? And the answer is yes. We're one of the largest, maybe the largest protection and advocacy organization in the United States, because there's one in every state. But we're very well connected. We use a lot of technology to connect, and we all communicate with each other a lot. We do trainings together. There's always emails going around about different issues. Then we also have work groups that we work on. So there's a bunch of different work groups for different issues, like discrimination, Lanterman, employment issues around the state. And so different people from all our different offices throughout the state meet up, you know, every few months to discuss those issues. Yeah, we love where we work. We're very lucky. Okay. And then this question says, you mentioned financial and medical powers of attorneys. Are there others? And so are there other power of attorneys other than medical or financial? Not that I'm aware of, right?
Not that I know of, but I don't want to give a definitive no way, but not off the top of my head.
Okay. And then the follow-up question on this is one type of power of attorney all-inclusive? And I think what the person's maybe asking is, like, can there be one power of attorney that is for financial and medical? And not that I'm aware of, but...
And
sorry, go ahead.
And because we're trying to... I think they're separate because medical decisions, like where you would send and the powers, kind of the information in the advanced power of attorney directive, using those intertwined, are really different than what would be in a financial one. So you would send your financial one to different financial institutions, but they might not need to have, they don't need to have that medical information. So I think that's why they're separate. That one you'd send to medical providers and one you send to any financial institutions.
Okay. And there's another question on this same one. Should power of attorney be completed and in place before they turn 18? And that mom I gave the example of earlier this week who was being told, or earlier in the presentation that I spoke with, who was being told you have to get a conservatorship. Her child wasn't 18 yet either. And she kept asking the same thing. She's like, can I put this in place now? Can I put the power of attorney in place? I said you would wait till after they're 18, but it's a very easy form. I would suggest reviewing it and before they turn 18 and really, knowing what the individual wants to elect as the powers the person would have in the power of attorney. So just really reviewing it before the age of 18. And then another question here. I could go to some of these. I was hoping to learn more about the pragmatic use and scope of these alternatives. I hope I might be able to protect my child's property and be able to reach him and assist him in case of hospitalization or his capacity diminishes. How can I find out more about the specific applicability or scope of these alternative devices? I was saying briefly when we finished the presentation, our office just came out with a great publication on alternatives to conservatorship. It's on our website, and I think it really goes into details about all of the different alternatives, like a lot more than we did in this presentation, and I would suggest looking at that. I mean, it's like a, maybe 10-page document, and it's a good resource to kind of get really in depth on all the different kinds of alternatives. We're also always happy to talk to people, individually if there's individual concerns or questions. So you could always contact one of our Office of Clients' Rights Advocacy offices. And there's a follow-up in the audience, and I'll repeat. Yes, and the audience member asked for the website of where the publication is, and yes, you're correct, it's our disabilityrightsca.org. And there's a tab for publications, and there's, and then you could click on conservatorship, and there's information about different conservatorships and a publication titled Alternatives. Most current, very new. Okay, another question. Does the Advanced Healthcare Directive apply to mental health services as well? And that's a really, really good question, and that's kind of the first question we had about the ABA services too, behavioral. We may have to do a little research on that to understand that better. It's such a good question, though, that I would recommend following up individually with our offices if you wanted to discuss it further. We just hate to give out information that wasn't correct. Really good question. Okay. Regarding the alternative ways that you talked about for people with limited verbal communication, how do we make sure doctors and other professionals respect the decisions made by someone with limited communication? How do we as parents make sure that happens after we die? I think it's making sure that you're letting the professionals know how the individual communicates. And I mean, I gave that example of when I was a support staff and I was helping the individual I served who wasn't being treated with respect and wasn't being listened to. It's kind of stopping things and explaining this is the way that my child communicates and we need to take a second to talk about that, or maybe even scheduling a separate appointment with the medical provider to just talk about their communication. And then, in regards to as parents, how do we ensure that this happens, in an ongoing way? I think that could be where the individual program plan, the IPP with the regional center could be really important, because there's a whole section, or there should be in the IPP, that talks about medical and different goals and support needs So bolstering that part of the IPP to talk about, exactly what kind of support and communication the individual needs to make medical decisions could be really important. And that way, any of their support staff that are helping them, if the parents aren't available or around, would, know that that's one of their needs.
And I just have something to add. We actually had a client who was raised and living with her grandmother, and her grandmother was really ill. And they had an IPP meeting where they discussed when the grandmother passed away. It was detailed in the IPP what were the next steps that were to happen. Who the attorney was that had her will and could carry out the grandma's wishes, and who would be staying in the house and living with the individual, and just was really, what type of support she would need, because when she was living with her grandmother, she didn't need independent living services, but when her grandmother passed, she would need them. She would need help, getting to the doctors. And that was all outlined in the IPP so that the regional center wasn't left scrambling when they got the call that the grandmother had passed away, and the client, could grieve without worrying how she was gonna eat or go food shopping. So those are things that can also happen in the IPP, regardless of whether or not someone is conserved. That's something that can be in the IPP, and it could change if you're, if the attorney that had the will changes, and that can change in the IPP. So it's really just, the IPP is a living document, so it can have the resources in there and information that can help the consumer.
Okay, and I'm concerned about the services provided by the regional center after I die. Is there a way to have my wishes documented long-term in the IPP process some way? Jalalia, she was ahead of that one. I think exactly what Jalalia just said, having the IPP meeting and documenting that, what should happen and what services need to be in place. Did you hear that? It was the same exact question you just answered. Okay, so the next question. Am I correct in that these strategies do not just apply to regional center clients? Yeah, I mean, Jalalia and I are most familiar in working with regional center clients, but I think as far as like communication and these alternatives, they apply broadly to all individuals.
We'll take the last of these so we can get back to the laptop.
Okay. My son will turn 18 next month. He desperately needs some dental work, and that cannot be done by the provider until April. He will not consent to treatment after he turns 18, and he will not give his parents authorization for treatment. Do I have any authority if this is detrimental to his overall health? What a hard question, which it seems like our office gets a lot of. So we're familiar with these types of situations. As we've said throughout this presentation, we're coming from the perspective of the client's rights, the Office of Client's Rights Advocacy, so the client's rights perspective. And, the individual has the right to make medical decisions after the age of 18 unless otherwise noted, so unless that right's been taken away. Okay. So the next one, our young adult daughter went to Future Ford in Sacramento and purchased a car without speaking to us. They doubled the cost of the car, sold it to her at 16.99% interest, and persuaded her to purchase every possible additional service. We returned to the dealership the next morning, and the minute the sales manager saw me, he said, "We didn't do anything wrong. To prevent this kind of thing from happening in the future, would a financial conservatorship be required, or would a financial power of attorney work?" I mean,
yeah, so we come up with versions of this too often, and I think obviously to start with the financial power of attorney, and there's times where we've been able to write letters and get if they were taken advantage of and it's a possible fraud issue, there's other means possibly to try first before doing the conservatorship. Yeah, so they're hard, and it sucks when you know, the things like that happen with the financial. But the financial power of attorney, I have seen it work getting out of a phone contract, where a consumer signed up for a phone contract and didn't realize just the amount of money that she would owe, you know, not only for the phone, but her monthly payment, and she had a limited income. And so her family had a financial power of attorney, and they were able to give it to the phone company and say, you know, she's not going to pay this, and she can't. And they went by that. So I think it's a good place to start, to try first.
Okay, another hard one. I have an adult that has a lot of difficulty with anger. She can be verbally and physically abusive. I'm wanting her to move out of the home, but she doesn't want to leave. What can I do? She's not conserved. Yeah, we are getting the hard ones. But this is a hard topic, so we're used to it. You know, that we can't advise too much, but, you know, the person's a tenant at the house, and so, you know, those laws, housing laws apply, right?
Yeah, and
it's hard. I would suggest having an IPP meeting to talk about, you know, what kinds of support she needs with the anger, and, you know, her choices as to where she wants to live, probably. And then, I'm in the Alta Regional Center area. Can I still contact you to follow up about the mental health services? What number do I call or email? And there is an office just like ours for Alta Regional Center consumers, and you could certainly contact our office and we'll direct you to that phone number, or you could look online if that works for you for the phone number to their office. But our office's phone number is 707-224-2798, and we could get you to the right place.
Gotta talk faster. We have a lot of questions.
Okay. Is there a less restrictive way to oversee the housing for my child, 19, other than a conservatorship? For example, I wouldn't want her to move in with a drug dealer. What are the options?
So obviously we don't have a perfect answer. I mean, it would depend on, you know, what she wanted, but I think one of the pieces is also we've been able to advocate for maybe the consumer to get some counseling from the regional center, or some other supports as to, you know, why does she want to live with a drug dealer? You know, if there's another way, but ultimately, you know, we couldn't advise unless we knew what she wanted. And so housing is a hard one. I mean, it is. Yeah, you guys are asking hard questions.
Good questions.
I mean, these are things that you're living with.
Yeah. Okay, advanced healthcare directive. At the dentist, my child gives permission for me to make decisions. She ends up having a cavity and then is afraid of the treatment, so won't let the dentist take care of it. What do I do? This one, I would recommend maybe again tapping into the regional center. Maybe the individual needs some behavioral support services to help her at the dentist. We've seen that be helpful for some consumers. And then,
I mean, because even if you had a conservatorship, so then they would strap her down. I mean, it's just it's not a great alternative. You know, like if you were forcing her to get the dental treatment that she didn't want, and she was conserved, you know, it would be a really extreme.
And in this case, it would also be important to look at if there are types of medical sedatives or things that could be done to ease that transition, and oftentimes those can be prescribed before the appointment to take something. So, just again, taking a look at the full range, because again, conservatorship doesn't always have the magic bullet to these either.
Yeah, I think those are both really good points. Okay, my son is 17, and for most of his life he has been denied services because my Annual income is too high. With a conservatorship, would my income still affect the services he's eligible for? So some example, ALTA, SSI, etc.
So I'm just going to speak generally. So once they're 18 and conserved, the SSI, they don't, I'm trying to think of consumers who are, yeah, they still get SSI even if they're conserved. They don't take into account their income, the income of the conservator. The only time that I've ever seen that be an issue is if a conservator was running a group home and the individual lived in their group home. And again, this is North Bay. I don't know if this is like a big policy. There's a concern of it being a conflict, so then the person is off of the group home rate and just gets in-home support services and SSI. So that's the only time that I've seen it affect someone in that way.
Okay. Why do you think even with alternative options, conservatorships are still sought by families and parents? It seems like there's an emotional, psychological issues at play versus what's really needed to help decisions be made. That's a great question. Almost like a thought-provoking for the room, right? I don't know if we have an answer to that, but I mean, historically, conservatorships have been in place for a long time for people with disabilities, and so, you know, they're still around, and I think hopefully, you know, more and more as we move forward and people with disabilities are given more access to rights in the community, you know, alternatives would be maybe looked at more frequently, I hope. It's a great question. Where can we get a copy of advanced healthcare directives and power of attorneys? When people call our office, I always say, you know, like Jalali and I said, Kaiser has one, you could contact them, and then you could also look online. Quick internet search, Google, California. I've also seen them at FedEx, Kinko's. They have sample forms there.
Yeah, there's like a model form. If you Google, there's a model form that goes by one of the probate codes. So if you just Google California power of attorney advanced healthcare directive.
And the person asked if there's a fee. We've been able to print them out for free. Okay, our daughter is institutionally deemed. If we do not conserve her at age 18, does the county or regional center automatically make decisions for her? She's 17, but is functioning at a 6 or a 7-year-old's age level. No, not at all. The regional center does not automatically make decisions for a person because they're institutionally deemed. They're totally separate. Institutionally deemed, is it like a complex kind of, it's very hard to explain, but it's a term used to help individuals who are regional center clients get access to Medi-Cal benefits when their parents' income is a little too high, or too high. And so it just doesn't have anything to do with the regional center making decisions for them. Great question. If we conserve our daughter, will that conservatorship pass on to our other children so that they can make decisions when we pass away? Not automatically. That would just, you know, I think it would need to be, the specific power of attorney would address what happens when the conservator passes away.
The court actually has to approve, I'm pretty sure the court has to approve any additional conservators, co-conservators, so you have to go through the process.
Okay. I wasn't my oldest son's conservator when he left and was missing, requiring a full-on rescue operation. I could have been charged tens of thousands of dollars, but wasn't because I wasn't his conservator. Do any of these conservator alternatives carry the same financial risk? That's fascinating. Not that I'm aware of, but I think it's a really good question that would have to be, you know, a little more research may need to be done on that. That is very interesting. What if the 18-year-old is cognitively 3 and doesn't understand and can't sign his name or even an X? I mean, it goes back to kind of like the individual, you know, us really having to look at every individual case and what works for the person. So I think it's, you know, developing supports for that person to get what they need to be able to make decisions as much as they can, and get supports to be able to do what they want. And then, you know, as far as not being able to sign their name or even an X, that's hard. Some of our clients use stamps. That's a legal form of signing your name. You can have a stamp made if that is something that may happen to work for this individual.
And I can just think of another client who we were working on trying to get him really complex. It was a complex nursing issue to get him nursing in his home so he could stay in his home, and he wasn't verbal, and he had limited communication, and we were able to do kind of the hand over hand X, because ultimately we wanted to help keep him in his home, and he was able to communicate with us that he wanted to stay in his home. He didn't understand that there was he might not have understood that there was a, you know, a huge legal fight going on to keep him in his home and get him services and supports in his home, but ultimately, since that's kind of the crux of what he wanted, that
worked.
Yeah, that worked.
Mm-hmm.
But
I think it's individual, case by case. That's hard when we have to answer that way, but it's true, I think. She's with, the individual's with foster care with the county. What happens when she turns 18 and is released? You know, it would go back to the IPP process with the regional center. Usually, I mean, there might be some different things going on with this person where they get a residential placement through the county over the age of 18, but the regional center would be a place that you could go to try and establish what would happen after the age of 18. Yeah. Okay. Finances can be an issue for families needing conservatorship. Are there any alternatives or community resources locally that can help? Not that we're aware of. We haven't seen anything. What is the role of the Special Needs Trust as an alternative to conservatorship? For example, using a special needs trust to direct funding. So, special needs trusts are established, you know, to help a person manage finances when they have, you know, maybe a settlement or money from their family, and then to keep their public benefits. So, as far as an alternative goes, I mean, it might be helpful for people who have a lot of more money and to remain on their public benefits to establish one. But we don't specialize in these types of trusts, and so I would recommend consulting with an attorney who does establish them to get more information. Do you know of any free or reduced cost resources to assist families in applying for conservatorship when appropriate? And that was same as the last one. We don't. I haven't heard of any. Okay. What can a parent do if the school district will not recognize my child's signed educational rights of authority form? Oh, that's interesting. I would recommend contacting an advocate or a special education attorney to talk that one through, right? I mean, and then I guess before doing that, maybe going up the chain, you know, make sure you're talking to the person in charge, that it's not just like a teacher saying this isn't valid. You're maybe going up to the district and going to the special education director. Yeah. There's a complaint process, Jalalia was saying, you know, that might be an option, but it's not good. Institutionalized entire life, has a parent now deceased, needs someone for medical and facility issues only. Is conservatorship needed? So we've worked with a lot of people in institutions who maybe don't have family and are still able to get access to services and supports without a conservatorship. So it is possible, and our office has a strong emphasis on helping people who have disabilities in institutions get support and deal with issues that are going on in the facility. So this one also may be one that you'd contact our office or our agency on. A person with a developmental disability would like their regional center to help them fund a limited conservator or find a limited conservator. This person is older and doesn't have any contact with any family members. Do the regional centers have a responsibility to help find a limited conservator? That's interesting. I think that it goes IPP process, going back to the IPP to talk about that goal and ask the regional center for help. That's really the starting place with requesting that the regional center help you is at the IPP. Okay. When it comes to limited conservatorship, does the client get to choose what rights they want to give the conservator out of the 7, or does the court decide? The court. How difficult is it to change a conservatorship? In our experience, it's very difficult, and we've seen a number of clients get denied that request. Yeah, throughout the years, we don't have any clients we've been able to help successfully change, and we've tried very hard. What's the cost? We're not sure. You would consult with someone who establishes them to ask their fees. How long is the court process? I think it would vary. Yeah, it would probably vary. And also, please address cost of getting a conservatorship. I'm not sure. I wish we could answer that, but we don't know. My daughter, who is developmentally disabled, would like to marry. However, she would lose a lifetime of medical, dental, and vision care benefits under my retirement plan if she's married. She would also lose her survivor benefits upon my death if she marries. Any advice? You know, as an office, we just experienced this with a client who's getting married, and it's like, it's so horrible how our system's set up that people with disabilities who want to get married do lose benefits. And we never advise for a client to not get married, but we would advise on all the benefits that they would lose and just being realistic about what that means. And I'd consider, you know, having a really real conversation with the individual about what it means. And it's just so unfortunate that that affects people with disabilities that way. These sources, like power of attorney and Lanterman Act, do they need to be obtained through the court, or is there a location we can obtain these rights and like forms and fees? And I think earlier we talked about, you know, how it's pretty easy to get the forms online, and then pretty much any agency you're going to work with, the regional center, different medical offices, different regional center providers, they probably all have their own release forms that the individual could sign and give consent for you or someone else to communicate with them about their services. So you just go to that entity and ask for their release form. It's pretty easy.
And I think this question, it had someone's name, so I'm just, you know, what financial and medical decisions are there for a particular individual? And with this decision, among others, how are the decisions affecting the family? And you know, there's another parent who's not constantly in this individual's life, and they don't seem to be a fit parent for them. I think this is kind of more family law area, but it seems like a difficult situation. But I just wouldn't be able to answer. Yeah.
Oh my gosh, so many great questions. I loved the questions about, like, if the power of attorney covers mental health and behavioral health services. We're certainly going to research that. And thank you all for your time.
The UC Davis Mind Institute was created in 1998 with a promise to find cures for neurodevelopmental disorders. Every day, our physicians and researchers come closer to fulfilling that promise. Their groundbreaking research on autism, Fragile X syndrome, chromosome 22q11.2 deletion syndrome, ADHD, and other brain disorders are helping children achieve their fullest potential. Please visit our website to find out more about current studies, upcoming events, and how you can help make a difference.